Okay, we're now live on YouTube. This is position 10, Marilyn Thompson versus Southern Auto Salvage. Ms. Thompson is present in court. She's representing herself. And Mr. Tell me your name again, sir. From Southern Auto Salvage, is it Valdez?
No, sir. My name is Muhammad from Southern Auto Salvage.
Muhammad.
I go by Jay, sir.
Jay. Okay.
Yes, sir.
I'm gonna call you Mr. Muhammad. Is that okay?
That is absolutely fine, sir.
All right.
Thank you.
Did I lose the court pod?
It's okay.
Because you gotta talk.
Judge,
Yes.
it's Matt Stone. You put Mr. Valadez in a separate room while he was sorting through his camera issues, but I think you put him back in the main room now. I see him.
Okay. Miss Mary, okay, I'm sorry. Miss Thompson, I got so many boxes open that I started scanning and I lose people.
Okay.
Would Mr. Muhammad and Miss Thompson please raise your right hand for me, please? Do you swear affirming the statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, Your Honor.
I do.
Ms. Thompson, you are the plaintiff in this case, and therefore you have the burden of proof and persuasion. So tell me what your case is about and tell me why I should rule on your behalf.
My case is I purchased a motor and a transmission from J Salvage. I have been doing business with him for over 8 years, and I really never had any problems with him. But the motor we purchased the next day when he finally got it, he had to send the tow truck driver out to get it. And each time after that, it kept the check engine. We wouldn't even get 4 or 5 miles away. The check engine light kept coming on. It said misfiring, advanced, different places we took it, kept saying the same thing. So finally, long story short, I took it to the Dodge dealer and they told me that the motor was bad and so was the transmission that I had purchased from Jay. This was, Your Honor, it was a period of over 8 or 9 months because we was making payments on it. And then Jay got sick during during November, December, and then he said he didn't have a mechanic. And when I told him, when I got the diagnosis after I spent over almost $4,000 with everything he said was wrong with it, I repaired it. And it was still the motor and the transmission was bad. When I took it to the Dodge Jeep dealer, that was the diagnosis that they have. And I have it all here in writing. Jay says, he wants to say that my warranty went out, but he never put a warranty on it because in the beginning, he never had the motor. So I was paying on it, and until I made my full payment was when he found me a motor. And then that motor that he did put in there, it wasn't no good in the transmission either. And I never thought he would say something like that to me after all the business I've done with him.
So ma'am, let me stop you because I didn't really understand what you just said about the warranty on the motor, but he never had the motor. What does that mean?
Sir, no, what I said was, it took him a while to find me a motor. And after he finally got me a motor, every time we left away from there, we wouldn't get 4 or 5 miles away. I had to call Geico over 8 or 9 times to tow that car back to him. The very next day after he
hold on, man. Hold on. I'm just trying to understand. So
Okay.
Is it your testimony that you want to, Mr. Muhammad, to ask for him to find you a motor and he found you a motor?
I paid for him a motor and a transmission.
Ma'am,
Sir,
you understand my question?
can you repeat it for me, please?
Is it your testimony that you want to Mr. Muhammad to ask him to find you a motor and transmission, and then he went out and found a motor and transmission?
And neither one of them was any good.
Ma'am, I need a yes or a no.
Yes,
Sorry.
sir. I'm sorry.
Okay.
Yes.
Because I need to understand. Because
Okay.
you have to understand that I'm gonna issue a ruling.
Okay.
So I need to be clear in what I'm hearing. So that's why I'm asking these questions. Okay?
Yes, Your Honor.
I'm not placing any value judgments on the testimony. I'm just trying to understand the testimony.
Okay.
Okay, go ahead, ma'am. I'm sorry, and I know that may have stopped you from where you were going, but, and this is for
You wanted a yes or a
everyone
no
here.
from me, right?
You answered the question, ma'am. I'm just
Mhm.
saying, go ahead now with your presentation of your case.
Well, Your Honor, this here took place over several months from the end of 2019 into the beginning of 2020. I mean, April of year 20. My son and I was working backwards and forth. Jay knew we was bringing him payments, installments until he find a parts. And then upon the conclusion of him doing the repairs, we had to pay him his full balance off. But after we paid him, the vehicle still wasn't running.
So let me ask you this. In the answer, there's a statement that there is a 60-day warranty on the motor and that they didn't receive notice about any issues until it was past the 60-day warranty period.
That's not correct, Your Honor. The very next day, he sent the tow truck driver to Covington from Douglasville because he said, don't drive it then. If it's making that noise, don't drive it. And so Jay himself, from day one, and that's what I told him, how can you put a warranty on a bad part? Every time we turn around, we keep bringing it back and it keeps saying the same thing, engine fail. But he said it needed a tune-up. We paid $823 for a major tune-up. We bought a alternator, a battery. All these things Jay said that the car needed. And then it still kept reading that the motor and the transmission was bad. And I have it, my letter from the Dodge Jeep dealers, Your Honor.
Okay. Anything else, ma'am?
That's it.
Mr. Muhammad, do you have any questions for Ms. Thompson?
No, Your Honor, I actually don't have any questions for her.
Okay. Ms. Thompson, you said you have another witness?
Yes, I do.
Okay. Mr. Hutchison, can we bring the other witness in, please?
He said he'll go get him.
Thank you.
You want me to sit in this chair? That's the judge up in the square right there.
Okay, sir, would you raise your right hand for me, please? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
I do.
You need to speak up a little bit louder, sir, okay?
I do.
Thank you. Would you please say your full name and spell your first and last name?
Rashad Ashton Thompson, Rashad Thompson, Thompson.
Okay. Now, Mr. Thompson, are you the son of Miss Thompson?
Yes, sir.
Miss Thompson, I'm going to ask Mr. Thompson his side of this case just to speed this along. Normally, you would be responsible for asking questions. So let's start, Mr. Thompson. What is it that you have to say about this matter?
I would like to say, well, going through it all, I used to tell my mom, I just felt like they were kind of like they wasn't really completing the job, because every time we paid them for something and we go and get the car, like it wouldn't even be 10 minutes before we leave and the car's already like acting up. And like every single time we invested a lot of money into that car to rebuild it. And it's just like every single time, like, you know, it was always a problem, whether we got an engine, whether we got a transmission, alternator. It's like they never, I don't even think they test drove it after they so-called fixed it or whatever. But the car was never repaired, and we spent a lot of time, money, and it was like frustrating. My mom was trying to help me out because I didn't have a car at the time, and like we were taking time out to just, you know, do this and that. We brought it to a few places. Like we brought it to one other place for like a second opinion, and the guy was like, well, this, you know, it's everything that we was getting from those guys, they were saying, well, it's no good or whatever. So
let me ask you this, Mr. Thompson. Your mother testified that she has purchased a lot of vehicles from, or a lot of parts from.
Right.
Yeah, a
Muhammad.
lot of parts. Yes, sir.
So that
actually,
would, hold on, sir. I didn't finish my question. So that would appear that there is a level of trust with Mr. Muhammad and the services that he was providing. Is that correct?
yes.
So is it possible that this is something that was out of character?
You mean as in this situation right now, like going to court?
Yes, sir. Yes, sir.
I don't think so.
Hold on. Let's stick with that. So you're telling me that Mr. Muhammad has been routinely selling bad parts to your mother, but you all would continue to go back to him?
Yes. I wouldn't necessarily say it was. We was. I would say it was one thing, and then he would say it was something else.
I don't understand that. My
That's not what
question
he
was
said.
very specific.
Yes.
Say that again.
May I speak, Your Honor?
Hold on, ma'am. This
Let
is
me
your
talk to
witness,
him.
and I'm trying to
I can talk.
get to the
Yeah, but
heart
you
of the
got me.
matter.
Okay,
So
can you ask that again?
hold on, Mr. Thompson. The question is, if your mother or your family has continually spent money with Mr. Muhammad, is it possible that the problem that you're having now is something that is related to the engine and not related to Mr. Muhammad?
I mean, I think Mr. Muhammad is responsible. Can you ask that question one more time? Because you said it different.
So let me, okay. Sir, if a restaurant sells you bad food one day,
Mhm.
but you've been going to that restaurant many times over, is it possible that that bad food that you received that day is a one-off, meaning it's not indicative of what that restaurant does?
Yeah, maybe so. Maybe that could be. Yeah.
So, sir, I need, because I have a bunch of people and I need to move through this. So, do you have any kind of specialized knowledge as to what happened with this motor, why it happened, whether Mr. Muhammad is responsible for it, or anything like that that the court can
Well,
base an opinion upon?
when the car, first of all, the car went bad on me driving it from work.
I
And
get
that-
that.
I
I'm
was-
going to accept that the motor and possibly the transmission was bad.
But this is what I'm saying though, sir. After the motor went bad on me, we went to, I guess, Mr. Muhammad. All of our, like, all the services was done through him. So like, if we paid him for a motor or transmission, anything after the car was, you know what I'm saying, was, well, we were trying to get the car back together. We went through this guy's services. And me and my mom used to argue a lot because I used to tell her, like, Mom, they're playing you. Like they're taking advantage of you. I don't know, it's because you're an older woman. I don't know what it was, but I always felt like they were taking advantage of my mom because she don't know about cars. She don't know. And I guess she had some kind of history with this guy before. So I don't know.
Yeah, Rashad didn't know him.
I never
Your
knew
Honor.
him.
Okay.
Yes, you got
Okay. Listen, we got to stay on track. Mr. Thompson, do you have any evidence to give other than the fact that the motor, in your opinion, was bad and that Mr. Muhammad did not repair the car as
Sir,
requested?
the evidence, I was amongst most of these, whenever we had work done on him, I was there. So I spent my money on it too. So I was there. So yeah, I do. I was there. Most of my cash,
Okay, can you get to that evidence, Mr. Thompson?
it's all right here. We have receipts on receipts. Like it's all right here. We have all receipts. Thousands of dollars we've spent with this guy.
That's damages. I understand damages. In civil court, there's liability first, meaning somebody is responsible, and then damages come second. That's where the receipts come in.
We got the purchases too, the receipts from purchasing.
Again, Mr. Thompson, those are damages. Right now, we're at liability.
Say,
Do you understand what I mean when I say liability?
no, I don't.
Okay, so if let's say I punch you in the face, okay, and then you have to go to the hospital and you incur medical bills. If we're talking about the medical bills before we talk about whether I punch you in the face or not, we're going backwards. So the first thing that as the plaintiff you have to prove is that Mr. Muhammad had a duty to you that he somehow failed to maintain or keep.
Yeah.
And then when we get to that point, the second thing we start talking about is what Mr. Muhammad owes you.
Okay, so am I wrong for saying that he never correctly put in the motor or the motor was never good?
If that's your testimony, that's your testimony.
That's the best way I can say it, sir. I don't know what else to say. Like, the guy never put in a good motor for the car. That's the only thing I can really come up with. None of the work that he done was valid. That's the best thing I can say. I spent my hard-earned cash. My mom spent her hard-earned cash. I don't know what else to say. Like, the guy never fixed our car. I ran into one of his employees at a whole nother shop, and they're
That's hearsay, sir. I don't want to hear what somebody else said.
okay. Well, I know I spent my time and money trying to get my car repaired, and it never happened.
I understand that. And I
So,
accept
I
that.
don't. Okay, that's all I can say. Like, that's all I can say.
I accept that. So when was the motor purchased? Motor and transmission purchased?
I got the transmission first in September, and we did some down payments. Cause you're honest, my son.
Ma'am, I'm talking to your witness.
Okay, well, she's gonna know everything by the date. She has all the dates and everything right here. So I mean, it's been so
So-
long ago. It's almost 3 years ago. So like, I couldn't tell you date for date, but I can tell you it was about 3 years ago.
Okay. And there's no question about the transmission. There's a question about the motor.
That's a question about all of it, sir.
So
All
you're
of
saying
it.
the motor and the transmission were bad?
The motor, the transmission, whatever else he did to it was bad. We went to another shop and let them take a second look at it. And the guy told us all of this is bad. This is bad.
Then we took.
Okay, again, that's hearsay.
I mean, what
You
else am
could-
I supposed to
You
say?
could bring that person in to testify that I looked at this motor and it was bad.
Yeah, I mean-
I can't rely upon testimony that I spoke to this other person that's not here in court, and that other person said that the motor is bad.
Hold
Yeah,
on, don't
but
say
this
nothing,
is
Mom.
from the
Don't say
Dodge
nothing. He
Jeep.
talking to me. You gotta
Miss-
let me
Miss
talk. He's
Thompson.
talking to me.
Ms.
Stop
Thompson,
saying that.
Okay.
you have testified, you have called your witness.
Stop talking.
I'm now questioning your witness,
Okay.
okay? So it was 3 years ago that it was purchased. Do you know about when there was any communication with Mr. Muhammad about the motor, transmission, everything being bad?
No, sir. My mom directly handled business with Mr. Muhammad.
So, Mr. Thompson, what are you here to testify about? If your mom handled everything, what are you here to testify about?
My mom handled that was her mechanic, but the car was for me.
I understand. I'm
And I was
asking, what is it, Mr.
I
Thompson?
witnessed everything, sir. So I mean,
Mr. Thompson, if you witnessed everything, you could answer my question.
so what are you asking me?
Are you ready?
I'm ready when you are.
The motor, the transmission, alternator, they were purchased when? I need date X for the purchase. I need date Y for when Mr. Muhammad was put on notice.
It was September 8th, 2019.
Okay, and when was Mr. Muhammad first notified?
September 8th, 2019.
So he was notified the same day.
Yes, the same day.
Okay, thank you, sir. See how easy that is, Mr. Thompson? Okay. Anything else, Mr. Thompson?
I'm good.
Okay. Ms. Thompson, I interrupted you before. It appears as though you had something that you wanted to say.
Yes, Your Honor, because my son didn't know Jay.
Ma'am,
You asked me a question?
yes, I did, but it has to be relevant. So for example, it would be not appropriate in court for you to start speaking to me about how church was on Sunday. Okay, because that's not relevant to what we're talking about. So the fact that your son doesn't know this person is immaterial. You're the person that
Okay.
called him as a witness, not me. So what else, man? And I'm sorry for being short with you, but I have other people that they're going to need their day in court too. So we got to hit the matter so we can get it done and we can move on.
Your Honor, the bottom line is, after all the service, I trusted Jay to do a good job for me, and he did not.
Okay.
He did
And you're
not.
requesting approximately $3,700.
Yes, sir.
Okay. Mr. Muhammad, do you have any questions for Mr. Thompson?
No, Your Honor, I do not, sir.
Okay. Miss Thompson, do you have any other witnesses or evidence that you care to give here today?
I don't have no witnesses, but I have all my documents.
Okay. And those documents related to the monies that you spent?
Yes, it is, Your Honor.
Did the car ever get repaired by a third party?
No, sir.
Okay. So I'm going to switch over to Mr. Muhammad now. And I can come back to you if I need to, if you feel there's something you need to, evidence you need to provide. Mr. Muhammad, what's your side of this case?
Your Honor, what I want to say is Miss Thompson, she's a very, very good lady, very nice lady. She's always been patient with me, what it is, what not. I know we had little hiccups with when the COVID started with my employee issues, what it is, what not. So we weren't running on schedule like we were before the COVID. So I was running behind with getting parts ready for my customers, whatever motor transmissions I'm selling. And then when the installation were coming as being installed, the motor and transmissions, we were about a month and a half behind. And she was really, really patient. Like I said, I have no problem with her at all. Even till right now, I'm just completely lost because I don't know why we are here we are right now. But I'm just going to explain to you what all is going on. Like she said, I known her for a long time, for years and years. She was actually referred me to one of my customers that used to work on her vehicle that left her stranded, and she knew where he was getting parts from. That's how she got to AJ. Alvin is, giving me a runaround. I think my motor's bad, what is, what not. I have given him the money. He's disappeared. I'm taking him to court and I need your help. And I was like, oh my God, I feel so bad, lady getting advantage. You know what I mean? I have mother, I have daughter, mom, everything. You know what I mean? So I know how it feels. And I feel her son too at the same time. But, like I said, she paid us for the motor. Engine was here. It's not that I had to order the engine after she pays me. Everything is here, but customers do have to pay up front before we pull their parts out, especially motor and transmission, Judge. Those are not small parts that will take a couple of hours to remove it from the vehicle. It takes time, and we have customers ahead scheduled that everything has to go timely, fashion way. So I cannot just jump on it. She was very nice about that. She's like, hey, he took my money, this and that. I need to get a motor. I'm going to take him to court. I need your help. Can you help me out? I was like, okay, no problem. Gave her a price on the motor. She came, paid, of course. I explained her everything. Hey, ma'am, listen, even if you pay me today, complete money, or even if you pay me, 2-3 weeks later, I'm not going to be able to jump on your vehicle or your motor right away because we have a lot of things ahead. And me and her always had a good communication. Never at all. No disrespectful, no nothing. You know what I mean? So that being said, she paid for the motor. I got the motor ready, this and that. I got the vehicle came in. Yeah, of course, the vehicle stood here for about a little over a month. Then it was supposed to be judged because the fact is the COVID happened. I got behind and we were shut down for a little bit with COVID, so all that. And she really understood everything. So anyway, we installed the motor in the vehicle. Car leaves out of here. No problem at all. Few weeks later, then she'll call, hey, the engine light came on. So I was like, okay, no problem. Bring the car here. We'll check it out. The O2 sensor is bad or something to do with the fuel pump in the vehicle. That has nothing to do with the engine. We installed the engine in your vehicle. What's in the gas tank in back of the vehicle or what's on your exhaust system that's under the vehicle has nothing to do with the work that we have done to the vehicle. Judge, the vehicle had a lot of issues with that vehicle. Keep in mind, Judge, before the vehicle came to Southern Auto Salvage, it has been to God knows how many mechanics, all right, that they have done backyard strictly work to the vehicle. Because when the vehicle came here the first time, it was in really, really bad shape under the hood. A lot of wires were, a lot of things were loose, disconnected. And I even told Miss Thompson about that. And she's like, yeah, I'll take it to Alvin Dix. And that was the guy's, her old mechanic name, Alvin Dix. And I took it to him, this and that. He messed up my car, this and that. I was like, okay, no problem. We'll try to fix it, what it is, whatnot. Long story short, I fixed the car. A couple of weeks later, then she has other issue. What is on that? We try to fix as many issues as possible with that vehicle in the warranty time and after the warranty time also, because I did not want her to think that, hey, I'm trying to get over what is whatnot. Judge, my thing is, you bring the vehicle here on a flatbed. The vehicle is not running. You pay the bill, but you drive the vehicle out of here. Now, keep it in mind, her son and her Miss Marilyn, the car would only run few miles. How would the car run few miles when I'm in Clayton County? You live in Douglasville. Your car is there.
No,
You
I live
call
in
me days
Covington.
and days.
Miss Thompson, please.
Can't say nothing.
You calling me days and days, weeks and weeks later after the fact that, hey, this happened, that happened, what it is, what not. And I'm still behind it. I'm like, the warranty's been over, but I will still take care of whatever it is. I have no problem. I have never charged her every single time the vehicle came here to diagnose the vehicle. When you go to a mechanic shop, they charge you $125, $175 hourly to diagnose what's going on. But I'm like, I'm not going to do that. I just need to know what it is, what not. So then, like I said, every time vehicle will come, it would have alternator issue or coil issue or this issue and that. And also, after the fact that the vehicle will come to me, it will go to different other mechanics. So she would have different mechanics coming to the shop or coming to her residence or where the vehicle was to check out what it is, what not. Because every time, Judge, the vehicle came to Southern Auto Salvage after her calling, what it is, what not, vehicle would always, it seemed like somebody has went under the hood, has tampered with a lot of stuff, what it is, what not. Every time my mechanic got under the hood, Jay, look at this, this is disconnected, this is cut, this and that, what is, what not. And I still took care of the fact that once you have somebody else go behind mechanics work, which is in the warranty, they will void the warranty, no ifs about it, because you already have somebody else check behind it, and I cannot touch it. I don't know what they did. And every time the vehicle came, it would have totally different issue than it would not be with the motor. Of course, the motor would not run if a mechanic will mess up the coil. If you mess up the wire, the car is not going to run. I told her the last conversation we had, there was a wiring harness issue, which I told her how much it's going to cost, what is, what not, because that is not in the warranty, and I'm not going to do that. She said, well, I took it to the Dodge dealership. They said they put a new wiring harness in the vehicle, and the motor and transmission is no good. You cannot tell me, Judge, that any mechanic out there, like the young man said, her son, that I took it to different mechanics for opinion, right? And they said the motor's no good, transmission no good. Sir, I have been in this industry since 1996. You cannot tell me that there is a mechanic, that good of a mechanic, that can just look at a motor or transmission or part and say the part is no good. Unless part looks like damaged, not good, broken, of course, that's common sense. But a perfect part, there's nothing wrong with it. By looking at it, you cannot tell me the part is good or bad, sir. And I mean, it's been, like she said, it's been 2019 when this conversation happened. We are in the month of 9 of 2002, years and years ago. The warranty on the parts are only 60 days. I still took care of the situations after for months and months, 8 months, 9 months, because even she had a health issue and I had the health issue. We both knew about that. She always worked me with the time. She's always been nice. I never have a problem because she understood what it was. You know what I mean? She's like, Jay, my son has messed up the car again. He has done something. He was driving, blah, blah, blah. Every time she would call me, it would be like, my son did this, my son did that. I'm like, we'll take care of what is on. Miss Marilyn, you need to let your son know. This car it's not a need of speed car. You cannot abuse a vehicle. It's an old car that has been through so many excuse my French, hell, but different mechanics going through what is what not doing really bad work, shade tree backyard mechanic work. That's what Alvin Dix was before she came to Southern Auto Salvage. He used to work at his house behind his backyard. So, Judge, all people working like that. I mean, that doesn't make any sense. How she's gonna come up to try to claim all this money that she wants of this vehicle, and the vehicle is not even worth that much money. Vehicle is only worth like $2,000, and you're not gonna sit there and tell me trying to sue me for that much money when it's not my fault. I have done everything in my power to make the situation as smooth as I could. After that, I just gave up because I'm like, I'm not gonna keep putting up with this because every day she keeps saying the same thing, but she does not want to do what I'm asking her to do what we got to do to take care of the situation. That doesn't make any sense to me. Reinstall the motor, transmission, or any part of the vehicle that we have done, Your Honor. It had a warranty of 60 days. We started this in 2019, Your Honor. We are here in 2022.
Mr. Muhammad, what does warranty cover?
Motor covers engine and the engine of warranty is 60 days, which is guaranteed not to smoke or knock, guaranteed not to, have excessive oil leak and stuff like that. Does not guarantee any electrical, any sensors, any coils, any wires, none of that. Your Honor, with the transmission is we guarantee the transmission to be you shifting in all the gears, not to be slipping and sliding. You have to replace all the seals, all the gaskets to keep the warranty, what is, what not. And that is it. If anything will happen with the warranty time, we'll take care of it. If it's after the warranty, I'm sorry, I cannot do anything about it. Most of her issue with that vehicle, Your Honor, Judge, is that, which I have told her so many times, please, Ms. Thompson, stop trusting people. Stop trusting people because you have these shady mechanics looking at it, trying to save money. God knows what your son does with the car and where he takes the car to a different mechanic that he doesn't even tell you half of the time that you have told me. I cannot keep doing that, trying to fix everybody else that has been through under your hood, trying to fix the issue, trying to figure out what's going on with the car. You have an issue, you need to come to me directly, what is, what not. And in the beginning, she did. I fixed the problem, there'll be another issue. But Judge, like I said, if the engine light is on, and if your code comes out to be for an O2 sensor, it is not on the engine, Judge. It is on the catalytic converter on the bottom of the vehicle, which is your part. If it has a code for a fuel pump, it's in your trunk. Has nothing to do with the motor, Your Honor. Nothing at all. That's other part that's of your vehicle that's gone bad. It's just like basically you were driving the vehicle, you get a flat tire. Hey, Jay, you put a motor in my car, now I got a flat tire. That doesn't make sense, sir.
I understand, Mr. Muhammad. So let me ask two questions. One, it sounds like you did receive notice within the warranty period.
Yeah, I have, and I took care of everything.
Okay.
And I still got notice after the warranty because I was getting calls from her, what it is, what not, and I still went a step ahead, and just to give her my good customer service, Judge, because she's my old customer. That's number one, And my thing is, Judge, I don't do any advertisement, none of that. My business is word to mouth. You know what I'm saying? I gotta make sure my customer, I give them a good customer service so they can send me other customers, which she has before.
The second question is, what is or was the vehicle inoperable?
When it came in, it was not inoperable. It was not running. It came on a flatbed. Every time vehicle has came here, it's not been running. It's been on a flatbed, sir. Every time vehicle has left out of here, it's left out of here, driven out of here, not on a flatbed.
Is that true, Ms. Thompson?
We drove that car to you. Your Honor, I had
Miss Thompson,
that is not,
just so you understand, when I ask a question, I ask it for a reason.
okay.
Is it true what he said that cars come on a flatbed and it's left under its own power?
Not true, Your Honor.
Okay, can you help me understand what took place?
We drove that car there, the Charger, to when he got out from work. I have a at the same time, and that, Your Honor, that car was a one owner. I bought that car from a Marine, and he sold it to me for $1,600 with
Ma'am,
What?
I
Okay, I'm
mean,
sorry.
you could have bought it from Jesus Christ. That
How
has
she get-
nothing to do with whether he owes you anything.
Well, Your Honor, the car we drove the car to that shop. It didn't come in on a flatbed. After he put that motor in there, the very next day, he sent me a flatbed from Douglasville all the way to Newton County where I live to bring it back to the shop because he didn't want me to drive it. The very next day,
Hold
after
on,
he said
hold
he
on,
put the
hold
motor
on,
in.
hold on, ma'am. So it's your testimony that the car was driven to his shop to receive a new motor and transmission,
Yes,
and
sir.
then you drove it away.
I drove it in there and we drove it out of there.
And then you notified him of a problem with
The
the
very
car,
next day.
and he sent a flatbed truck to pick up the car, presumably to bring it back to his shop.
Yes, sir.
Mr. Muhammad, what
Yes,
was
Your
the
Honor.
problem with the car when it was brought back to you?
She said the car has an engine light on and it was overheating. So got the vehicle, of course, it was a warranty. Got the vehicle, I definitely told her, yeah, not to drive the vehicle because you're in the warranty. You don't want to break down. That's number one. And for God, if something else happens than what the issue is already, we don't want to escalate the situation. So of course, I sent them tow truck up there, got the vehicle picked up to put the light on. I put the scanner on the computer of the vehicle to find out why the engine light is on, and it was the temperature sensor. So I told my guy to go ahead and clear the code and see what happens if the light comes back on. Why did the code come back on? He cleared the code, and 20 minutes later to find out her electrical fans there on the vehicle, they're hooked up right behind the motor. Her fans are not working. The fans were no good. Evidently, fans work, and then it will just cut off. It won't work. It was basically sending a signal to the temp sensor that they're not good. That was the reason why the engine light was on. So we replaced the sensors, we replaced the fans, and everything was fine. She drove the car back out of the shop. No problem, of course. No problem at all, of course. It was on warranty, we'll take care of it. Even the fans was not in the warranty. Even like I said, we don't warranty any sensors, any gaskets, none of that. Her sensor light came on. I even replaced that in the warranty, no problem.
Okay. Ms. Thompson, do you agree with that?
Absolutely not.
So you're saying he did not repair the car at all?
All of that, he's talking about an O2 sensor. No, my car was not running hot.
He said it was a temperature sensor.
No, sir. Napa Care, I had a heating problem when Rashad was driving it. That was way before we even brought it to him. To Jay, you never replaced anything in my, all that you talked, the O2. No, sir, Your Honor.
Ms. Thompson, to your knowledge, what is it that Mr. Muhammad did to the vehicle when it was first brought back?
Mr. Muhammad had my car for periods of time, and sometimes he had it, sometimes he had to go back and pick it up because he didn't have space and he didn't have a mechanic, and he was in the hospital at a time, and then I had a back surgery. So a lot of things transpired, Your Honor, over a period of time.
Ms. Thompson, can you repeat my question back to me?
No.
Because you're not answering my questions, and I don't. And
Okay.
and I'll tell you this in all fairness, as a judge, when a person doesn't respond to a question, that can be an indicator of deception. My question was, the first time the car was brought back, what is it your understanding as to what he did to the vehicle?
He was supposed to put a motor and a transmission in it.
Mr. Thompson, did you hear my question?
Yes.
Can you please translate it to your mom? Because I don't.
He's saying, what did you think that he did to the car?
I don't think he put good parts in my car, Your Honor.
So what do you think he did?
Because we had to go
Mom,
right
listen,
back
he
to
asked you one question. He asking you, what do you think he did to the car?
nothing.
Okay, that's all you had to answer him.
Thank you, Mr. Thompson. So ma'am, if you didn't think he did anything to the car, why did you take the car back?
Because I had given him my money.
So it is your testimony that when you picked up the vehicle and the vehicle broke down, he sent the flatbed, he didn't do anything to your car, but then the car left under its own power. That's what you're testifying to.
And before we can get to my house, the car had to go back to him, Your Honor. Yes, that's what I'm testifying to.
Okay. Can I ask you this question? Well, I am going to ask you this question. I don't need your permission. Why would you pick up a vehicle that you believe the person didn't do anything to fix it? Hold on, Mr. Thompson.
It was all indication, Your Honor, that the car wasn't running right. The check engine light came on. It stalled out before we can even get to Covington, halfway from J Shop. If you just put a motor in my car and it's stalling out already.
Mr. Thompson,
Yes.
go ahead, sir. I interrupted you.
Whenever we brought our car to him and drove off with it, it was with the mindset of thinking that the car would be running properly. The car, anytime we pulled off from his shop with that car, we would have to get it towed back to the shop. So like, the only reason she's bringing the car to him is because she's paying him for her services. And he's not fulfilling the services. He's not.
Thank you.
Cars were never fixed. And then half of the stuff that he's talking about, it was like, I don't even understand how he's even talking about it. He's just telling a bunch of lies.
Because he never did none of that.
Hold on,
He's
Mr.
telling a
Thompson,
bunch of
please. I'm
lies.
speaking to your son now.
I
I've
can talk.
I've
clearly.
tried to get answers from you, Ms. Thompson, and I have not. So
My
I'm
mom,
going to speak to Mr. Thompson right now.
Yeah, excuse me, sir. My mom, she sometimes she corresponds stuff. It takes a minute, but this guy has never.
Don't say anything about Mr. Muhammad's character. I understand.
No,
that
I don't disrespect him at all. I don't have no bad issue with. I mean, we just pay him for his services. He never fixed our services. I don't have an issue with it. I don't think he's a bad guy. I just don't think he did a good job with our car or any job at all. Like anytime we went to go get the car, because 9 times out of 10, I was the person going to get the car. And I would call my mom and say, hey, well, I thought he fixed the car. I thought he fixed the car because it's running. I mean, I got to pull over. It's shutting down on me again. Like that happened multiple times. So like, I don't understand what he's claiming he fixed. And we already had like all the little stuff he's saying. I don't even think we had that stuff like fixed on there. Like I don't.
Okay. So before I issue a ruling, I'm going to give Mr. Muhammad and Ms. Thompson the opportunity to give what we call a summation. You don't have to, but it's basically you tell me why I should rule in your favor. We're going to start with Ms. Thompson.
Let me see. He asked him to me.
Can I ask her something before?
Yes, sir.
He asking me to speak. I don't need you to tell me to say anything.
I'm not telling you to say anything. I'm just telling you.
Your Honor, the reason I believe you should rule in my favor is because the fact stand, I would never accuse nobody of something that they didn't do. if you took your car to a shop and you had to bring it back, I can bring my receipts from Geico 9 or 10 times having that car towed. Soon as we would get it back, it would be shutting down. You would get 3-4 miles away. Mr. Muhammad knows this. I wouldn't be sitting here for no reason. We spent our hard-earned money. We had to do layaway payments with Mr. Muhammad to get that car fixed. My son had to wait and work, and when he would get off from work, we would go and pick up that car. I had other people helping me to bring that car backwards and forth to him over look like 9 months period of time. Never could get the car right. And that's why, Your Honor, I feel like you should rule in my favor, and I have my facts in front of me. I have all my receipts, and I have, when I took it to the Dodge dealer is when Mr. Muhammad blew up on me. Well, the dealer gonna always tell you this and that. And when my son said we took it to different people, it was like you took it to the AutoZone and let them read the sensor, and that's why they kept saying it was misfiring. It's in the motor, something in the motor. And that heating stuff what Mr. Muhammad is talking about, he never had to do no heating on my O2. He never had to do no work on my transmission. I mean, my
He said it was
water
replace the
pump.
fans and replace the
Yeah, no, he
the
never
temperature
did no
sensor.
work on my car. Never. And that was the one I bought that from a Marine, Your Honor, that Charger.
Again, Miss Thompson, you could have bought that vehicle from Jesus Christ.
Okay.
It is not going to sway my decision in any way or the other.
Okay.
Mr. Muhammad,
Yes, Judge.
I'll hear from you, sir.
Judge, I think it needs to be ruled in my favor because I have not done anything wrong to her vehicle. That's number one. Yep, they provided me for the service, which I provided them. They paid me for the service, which I provided them again and again in the warranty time, after the warranty time. Now, if the vehicle was keep coming back here with the bad engine and I was putting an engine in there and engine went bad again, or same thing with the transmission, that would be a different story, Judge. As you see, you will obviously, Ms. Thompson has all the receipts and I have all the records of every time vehicle came here, what we did, what not, you know what I'm saying? Every time you will see the vehicle has a different issue. It has never came with the same issue, number one. It had all kind of electrical issues from day one, from front to back, side to side. She keeps saying the motor is bad. Dodge dealer even telling her, she's saying the engine is bad. I was like, okay, bring me the paperwork, what is, what not. The wiring harness is all messed up. Everything is on the paper. It has nothing to do with the work that we did, Judge. And like I said, Judge, you paid me so much money to give me the service that you wanted, right? I provided all the service. So why would you keep paying me for years and years then? And why would you wait that long? And why would you every time come here and you will be able to drive the vehicle here, but then the vehicle would have to get back towed? That is my thing. And, you know, again, everything is in the warranty. Anything to do with the motor, you know, like I explained earlier with, you know, knocking, smoking, this and that, what is, what not. Warranty says clearly, if you do not warranty any gaskets, any seals, any sensors, what it is, what not. Motor is guaranteed not to smoke or not. And the vehicle does not have that issue. It's got electrical issues, which again, I've tried to take care of as much as I can. But every time I do something, vehicle comes, whenever if vehicle will come back, it'd be like somebody has tampered with some stuff. Half the stuff will be loose, what is, what not. And it's been out of the warranty and I still took care of it. And I mean, I don't think that's fair to me or my company, you know, to be reliable for this when it's not our fault. It's not that I took her money and told her that I'm not going to do anything with your vehicle and take your vehicle out of here. I provided with every service there is that she had paid for and more and beyond, you know what I mean? Because I know she was going through a situation and everybody does end of the day, you know, and it's not like I'm saying that I had a petty on her, never, you know, neither did she have a petty. It's just a communication, you know, and, you know, we had that understanding, you know what I'm saying? A human to a human, that's all it was. And that's where we're at right now, Judge.
Okay. I've heard the evidence. I'm going to rule on behalf of the plaintiff, Ms. Thompson. The judgment is going to be for $1,500. I believe that Mr. Muhammad is entitled to the work and effort that he placed in placing the motor in the car, changing it out, all that kind of stuff. I do believe, Mr. Muhammad, that once you placed your hands on the vehicle, you kind of accepted what was going on. And it appears as though you were trying to accommodate Ms. Thompson. And so I'm not gonna hold you fully responsible as it relates to the money that was owed. So Ms. Thompson, there'll be a judgment in your favor for $1,500 plus $100 court costs. It appears that Mr. Muhammad was trying to do the right thing. But unfortunately, Mr. Muhammad, you're sort of in a position if somebody comes to your shop to get their car fixed and they're paying you to have their car fixed, I don't believe it's an unreasonable expectation that the car will be repaired. And I do take into account what you said about the condition of the vehicle and the things that you had to deal with. But it may have been in your best interest to not even touch it. Okay, sir?
Judge, I understand, but I don't think that this is fair. It's not fair at all because the fact is that we have Southern Auto Salvage has put a lot of time and a lot of effort in that vehicle to keep it, to do what we had to do and more and beyond. And after the fact that, she has different mechanics going to the vehicle and messing up, it's not Southern Auto Salvage's fault. Yeah, I took the vehicle. Yeah, understand that, just to take care of a customer at the end of the day, to do what we do and give her our customer service. I'm not going to be like, yeah, I'm not going to serve you, but I will serve you. I'm not racist. No, we don't do business like that. And I gave her 110 customer service, that I do to every other customer, no buts, no ifs about it. Now, vehicle came up with more issues. It's not really my fault, but I don't think this judgment is fair, sir.
I understand. If you want to appeal this.
Oh, yeah, definitely. I'm going to have to because that's not right.
You're going to have 30 days to appeal to the state court of Clayton County.
Okay, so 30 days from today, right?
Yes, sir.
To state court, right?
Yes, sir.
State court. Okay.
So it'll probably take maybe 5 to 7 days for a judgment to be entered.
Okay.
Once that's entered, you can receive a copy of it, and it'll be under this case number. So you can.
Yes, same case number. I'm sorry, Judge.
Yeah, no. So it'll be under this case number. So when you file the appeal, it'll be under this case number. You have to pay a fee for the appeal.
Of course.
And then it will it'll get assigned a new case number.
Okay.
Okay. All right. Yes, sir.
So, Judge, I'm sorry. Just one clarification. Basically, yeah, you said about a week or so before the paperwork's processed in the computer, what is on out. So basically, I should just wait for like 2 weeks or something, and then I can go to Clayton County a state court to file an appeal on this case number.
Yes, sir.
Perfect. I just want to make sure I understood you right, sir. Thank you so much, sir.
Okay. Have a good day, Mr. Muhammad. Miss
Yes, sir, you too.
Thompson, you and Mr. Thompson are free to go unless you have any questions.
I have a question.
Yes, sir.
Will we be able to appeal the case too?
You can do a cross appeal when he appeals. I mean, you won here today. So,
Right. So it's nothing else. we
you
need to
don't
do.
generally appeal a win.
Right.
But if he appeals, you can either respond to his appeal or you can file a cross appeal.
Thank you so much, Your Honor.
Okay.
I'm sorry I didn't give you the right. I mean, wasn't answering your question. I was explaining the best I could.
I understand, Ms.
Thank you.
Thompson, and that's why I try to use analogies to try to let people understand what it is that I'm asking for.
Yes, sir.
Because only lawyers are crazy enough to live their life in a courtroom, not
Thank
regular
you.
people. Okay, ma'am, you and your son are free to go. Mr.
Thank
Hutchinson,
you.
does that allow me to close
Thank you, baby.
this pod?
Yes, Your Honor, that's everyone else in the courtroom is gone.
Okay, thank you, Mr. Hutchinson. You can close out whenever you're ready.
Thank
Now,
you.
I
Wait,
have,
wait, wait, hey, hang on.
yes, Mr.
This
Stone.
Matt's, yeah, are we gonna get to our case?
Well, that's what I was about to address.
Oh, sorry, Your
I
Honor.
have Mr. Looper, Mr. Stone, Miss Amin. And I'm going to try to move these cases along from shortest to longest. Mr. Stone, or take into account any conflicts. Mr. Stone, since your case has been appealed, I mean, not appealed, been continued. I'm inclined to deal with your case first, but I think there are a
Thank you.
number of witnesses in your case.
One for the defense, Your Honor, and I believe the plaintiff is his own witness.
Okay, and Ms. Amin, you're representing Mr. Washington.
Yes, Your Honor. And one of them, I just wanted to bring to the court's attention that one of the mechanics that looked at his car changed dealerships, and we had an issue trying to locate him. We just located him over the weekend, and we had him on the line to appear today, but the manager of the dealership said that we would have to subpoena him, and we were not able to subpoena him because he had moved from the last dealership that he was at. This is a 2019 case. So since then he changed employment. So we had to basically track him down in order to find him. And he was on the Zoom this morning, but the manager said that we would have to subpoena him at the new dealership in order for him to appear.
When you say, you're saying the manager at the new dealership is saying that he should be subpoenaed.
Yes, he was at another dealership when he
Okay,
looked at
no,
Mr.
no. I'm just trying to clear it up, ma'am. I heard everything. I'm just trying to make, because the way that it came out, I didn't understand if it was the manager from the old dealership or the manager from the new dealership. This witness, as far as I'm concerned, is on a subpoena from before. And so you may want to contact that that person to let them know that if they don't appear, that I consider them to be on the subpoena, and that may be a problem. Mr. Looper.
Yes, sir.
Your case, let me see. There is an issue. It was with Miss Dent and Mr. Dent.
Yes, Your Honor. I think by starting addressing the procedural question about, as to Ms. Dent, there's clearly a default. So the only thing that's required is damages. As to Mr. Dent, he did file a pro se filing.
Okay.
I'll be asking you to make a ruling on that initially, which would then either truncate it or take longer to prove liability.
Okay, and Miss Amin, feel free to contact that person while I'm clearing, because I'm clearing my calendar, clearing up my calendar so that we can have these hearings.
Yes, Your Honor, but for clarification, the other dealership was not subpoenaed because he no longer worked there.
But he was under subpoena the first time, correct?
Not by the prior attorney. I was just retained on this a week or so ago. But when we were locating the witness, we were not able to subpoena him because he no longer worked at that dealership. He had moved, so we had to track him down.
That's a different matter. Is Miss Gray still here?
Your Honor, I'm sorry. Yes, sir, I'm here.
Okay, ma'am. The new image towing has not appeared. And I did see your answer, read your answer. So this matter is going to be dismissed for want of prosecution. You're free to go.
Thank you, sir.
Miss Martin, you appear to be new. Where did she go? Okay. Miss Martin, would you unmute yourself, please, ma'am? Please, ma'am.
Yes, sir.
I I don't recall. You do you have the YouTube on?
No.
I'm getting an echo. I hear myself speaking through your computer.
No, I don't have on YouTube. It's probably because it's connected to my car. I can disconnect it from my charger in my car. I'm sitting at my son's school.
Ah, so it's coming through the audio system in the
Through
car.
the car. Yeah, that's what I was saying. I can unplug it if you need me to.
Miss Martin, what case are you here on?
Um,
Position 12. That
it's
case has
with
been
Miss.
dismissed, ma'am. I mean,
Okay.
it hasn't been dismissed. There's a motion filed to strike your answer because you wasn't here at the call of calendar. And I granted
Yeah,
that.
I thought my hold on one second. I thought my timing was at 1:30. I didn't know it was at 8:30 this morning. I had an IEP meeting at my son's school this morning. If I would have known, I would have been on this morning. So I tried to call the courthouse and she told me to try to get on Zoom and see if you guys were still on.
Okay, we are still on, but Mr. Whitten, who was the lawyer for Midland Credit, he has handled his matters and he's gone. So when you're not present at the call of the calendar, your case can be dismissed, meaning your side of the case. What I would encourage you to do is to contact Mr. Whitten and to have a conversation with him about reaching some sort of agreement.
Okay.
All right, ma'am. You're free to go.
And you said I need to contact, what's his name? Do you have his direct contact information or do I just need to call?
The contact I have on my calendar is for a Joshua Orem, OREM, phone number 470-240-3440.
Thank you so much.
You're welcome. You're free to go, man. Mr. Stone,
Yes, Your Honor.
I may disappoint you.
Oh,
You may get bumped down to number 2.
I'm used to it.
I think Mr. Luper's case is going to go pretty quickly.
Okay.
And I do contemplate that this is going to be a long hearing as it relates to your case.
I would imagine 15 minutes at the most from our side,
Okay.
including
There's,
cross-examination.
as I say, the first thing you learn as a judge is that people definitely underestimate their time.
Yes, sir.
I had one judge that I told 15 minutes and I finished in 10. And he was like, "You're the first lawyer that has ever kept your word as to timing." So Miss Amin, we're going to move forward on that case. I'm going to deal with this issue with Mr. Luper and Mr. and Mrs. Dent.
Thank you, Your Honor.
Miss
Your
Dent.
Honor, I'm going to step away for just a moment. I'll be right back.
Yes, sir.
Thank you.
Miss Dent.
I'll sleep later.
Miss Dent.
Yes.
I'm looking at the notes from your file, and it does appear as though you did not file an answer.
My husband did.
Okay. So, to the extent that you're both being sued, you both were in a position to have to file an answer. Now,
Thank you.
are you able to stay with me, Ms. Dent?
Yes, I have to just step out real quick.
No, I understand. So, because the two of you are married, there may be some issues related to how a judgment can be collected. And what I mean by that is to the extent that both of you were sued individually and you're married, theoretically right now you're in default status, which means a judgment can be entered against you. However, being married, it
Can y'all give me a
becomes,
minute?
are you able to devote your attention to me, Ms. Tent?
Yes, sir. I'm at work and I'm just moving employees back out of the office, but yes.
No, and I understand, and you know, when the notice of come to court basically says, laying all business aside, you are to appear. So it doesn't mean that you can continue doing your business
Right.
and be in court at the same time.
Okay.
But I'm gonna give you you know, understanding. And we're gonna try to
You
move.
have my undivided attention, Judge.
Thank you, ma'am. So because you did not file an answer, you're technically a non-party at this point to this action. And your husband is the person that is able to be here as a party. So the answer, it just says, you know, Benjamin Dent. It doesn't say Benjamin and Patricia Dent. Do you understand that?
I understand what you're saying. Yes, sir.
Okay.
If
The
I may, Your
answer
Honor.
was from the two of us because we are married.
No, I understand, but that's not the law. It's like if you decide you're gonna drive on the wrong side of the street one day, you're driving at speed limit, but you're on the wrong side of the street.
Mhm.
So Mr. Looper, I'm going to rule in your favor as it relates to Ms. Dent for now. Do you have anything to add, Mr. Looper, to my current understanding?
Well, Your Honor, if I may, depending on your ruling as to Mr. Dent's filing, I will either prove damages as to both defendants together, or I'll need to prove liability as to Mr. Dent and then prove damages for both. So to the extent you told her she's not involved, as she's technically a third party, I would suggest that to the extent that we have to still show damages against her, which we are prepared to do, she would participate in that portion of it either way.
Let me ask you this question. Given the fact that they're both married, and I'm assuming they both live at the same residence?
I believe they were both served at the same location, yes, Your Honor.
So wouldn't proving damages against one prove damages against the other?
I mean, it's 6 of one, half dozen of the other. I mean, it's just a different way of phrasing it. I would suggest that once we establish liability, either by your ruling or by putting on evidence as to Mr. Dent, then we only need to put on damages once as to both. They will be the same. I'm just suggesting I wouldn't want to put on damages as to her now and then let her go. And just it would be kind of putting the cart in front of the horse, but I'll follow the court's instructions.
Well, and I'm setting that the damages issue aside at the moment. I'm going to ask you some questions about the answer. It appears as though there's an answer filed, and it was in sort of long format. And it was filed July 30th of 2021. What is it exactly is your legal issue as it relates to the answer?
Your Honor, I understand that pro se defendants file pleadings. While on the one hand, by law, they're held accountable to the same level as an attorney, there's some discretion from the court to, provide some understanding as you have here today. That said, looking at the substance of the response, there was no legally sufficient defense raised as to why assessments weren't duly owed or paid. The thrust, and I don't represent the defendant, but the thrust of their answer was that they didn't know about the HOA and the HOA didn't do anything. Well, those aren't legal defenses to non-payment and for liability, especially for liability. As the evidence will show when we present our case, the covenant was filed on behalf of the HOA prior to the defendant's deed in the public record. Under the POA Act, I don't know how familiar you are or not with that act, but under the POA Act, Property Owners Act, they would be required to be bound by the covenants of the association where they have their deed. So that would make that legal argument moot. And also there's a series of cases in Georgia that say, arguing about the sufficiency of the benefits you get from the association is not a defense for non-payment of assessment as they accrue. And that's essentially all that's raised here. So I would say, again, it's a technical and a substantive reason.
Let me ask you this, Mr. Looper, and I'm going to come to you, Mr. Dent, for a response. But essentially, when you move into a neighborhood that has an HOA or a covenant, it's a contract, and you're agreeing to abide by the contract, correct?
I would agree with that, yes.
Mr. Dent, when you moved into this neighborhood, did you sign off on a contract?
No, I did not.
Are you sure?
I'm positive, Your Honor. I asked for a home when I was buying it for my retirement that didn't have a HOA. That was in my contract.
It was in what contract?
The contract, my closing contract when I bought the house, it said no HOA. I highlighted it when I first got a letter from them and sent it back to them.
Mr. Looper, do you have evidence of an agreement signed by either Mr. Dent or Ms. Dent or both?
Okay. Well, Your Honor, I would suggest that the closing documents or any contract that the defendants had with any realtors or the owners of the property previously are not relevant to the legal obligation they have with the HOA. I would draw your attention to OCGA 44-3-223.
-3-223?
I'm sorry, correct, 44-3-223.
Okay.
Every lot owner and all those entitled to occupy a lot shall comply with all lawful provisions of the Property Owners Association instrument, period. That is the crux of the agreement they reach or are obligated with the association. Under Georgia law, once an association files the covenants in the public record, and again, I could put the witness on, and although you can take judicial notice, since we're discussing it. So, and I submitted it as plaintiff's exhibits 1 and 2. And I just spoke with your staff to try to share those documents with the defendants. And she said she's sharing it with you, but she's not able to share it with them. I can share my screen on my desktop and the defendants can look at these documents as well. I wasn't sure logistically how you handle documents, but that said, very briefly, Exhibit 1 is the covenants that were filed in the deed and record book, May of 2006. The quitclaim deed by these defendants on the property, plaintiff's exhibit number 2 in the public record, deed and book, were quitclaimed in July of 2019, well after the covenants. And
Okay.
again, I would ask the court to take judicial notice, put them into evidence, but you can get to that when you'd like to. But to answer your question in terms of binding contract on these parties, between Georgia statute, the Property Owners Act, which I cited, and there's more to the act, there's more case law I can cite to you, but that's the crux of it. Along with these two documents, they are bound by it. Now, to the extent that their realtor did not provide information or provided the wrong information, that may or may not be something between these parties and third parties, not here today. But, you know, if a closing attorney doesn't reach out to the HOA and get information from the HOA, that would be them dropping the ball. It's not a change to the law or the obligations that the HOA maintains. And I can go into as much detail as your Honor cares to hear, but I think that's the crux of it.
No, I understand. And the reason I'm asking these questions is just so we can narrow the issue to
I understand.
to what we're dealing with.
Can I add something, Your Honor?
Yes, sir.
Okay, I heard him say that he put those in effect in 2006, and in 2019, something happened. I bought over here in 2017. Nobody had HOA, nobody talked about HOA.
The house is built.
I bought in 2017. He talking about 2019. 2019 was when I first heard they sent the first thing to my mailbox saying I owe XYZ. I'm like, whoa, what is this? Now, he got somebody that's supposed to be the president. She told me, well, we talked about this. I don't.
Mr. Dent, I need you to stay as focused as possible.
Okay.
I didn't mean to cut you off. I just said, because when you're like going, she said,
so okay, I got you. But I'm saying in 2017 is when I initially bought that property. There was nothing about an HOA.
And Your Honor, if I may, it's the same argument, whether it's 2017 or 2019. And I appreciate Your Honor focusing on the legal issue before us, but if we are going to get into testimony, if we can swear in the witnesses and approach it that way. But I understand what your point is right now.
Yes, sir. Because this is magistrate court, sometimes it's best to be as accommodating as possible to get the information out. So let me see. I'm looking, Mr. Looper, at the covenant.
Yes, Your Honor.
And I don't see a date. I'm missing a date.
On the first page of Plaintiff's Exhibit 1 for identification, there's both a stamped filed, Clayton County, May 25th, 2006, as well as a handwritten date in the body of the document, April 28th, 2006, on the first page.
Okay.
And then actually there's a book there's a book and page number on the lower left-hand corner.
I do see that, and I do see the filing date, and that the covenants were entered into or filed on April 28th of 2006. So, Mr. Dent, it would appear that these covenants were in place when you purchased a home, and it appears that it was done through a quitclaim deed. Was there ever a general warranty deed entered into?
No. I didn't really do a quick claim deed. I bought VA.
So the plaintiff's exhibit 2 is a quick claim deed that was entered into on July 11th of 2019. And it has your signature.
That was a refinance.
Teresa Hinton. I'm sorry, sir.
That was a refinance for a lower interest rate.
So when did you purchase the home?
2017, June 2017.
Okay. And that was through a warranty deed.
Right, VA loan.
Was it one where you took over the?
No,
okay.
I had to go through the whole process.
And honestly, I'm asking because I don't know the question. Who allowed you to refinance through a quitclaim deed?
I refinanced twice since I've been in there to get to the 2.25 where I'm at. So first time I refinanced was Linden 3. Next time I refinanced was Caliber Home Loans.
And Your Honor, I'm sorry to interrupt, and I understand the purpose of your inquiry, but if we are going to be precise and we're going to go forward with a hearing.
Mr. Looper, let me stop you. We haven't started the hearing yet. I'm trying to, so that we're not wasting a lot of time.
Respectfully, Your Honor. And of course, but my point was simply that if in fact we're going to have to go forward on these issues, so we are not redundant and have to swear him in a later date for, he's going to be doing this on his portion of the hearing. I'm just suggesting it would expedite it by actually putting the testimony officially in, especially as to documents in the public record, which I'm not aware that they're presenting any today.
Well, no, I understand that. And believe me, Mr. Looper, this is not to disparage attorneys because I am an attorney before I became a judge.
None taken.
But attorneys sometimes put on a show rather than getting to the heart of the matter. And I try to get to the heart of the matter so that I can understand, because just with this conversation, Mr. Dent, it appears as though there was an HOA that documents have been filed, and at the time that you purchased the home, that there was an HOA and there were covenants in place. So I say that to say that if we're going to have a trial, it appears that Mr. Looper is going to be able to prove his case. And for your benefit and for Mr. Looper's benefit, sometimes people, they say, well, if I just can get before the judge, I can cry hard enough, or I can tug on the judge's heartstrings, or I can do whatever. My job is to follow the law and to be as dutiful to the law as possible.
Well, I understand that, Your Honor, but what I'm saying is that I didn't know, and I don't believe they was taking payments in 2017 when I got in there, because it was all over the place. And then if you got a covenant, I tried to buy in there years before and didn't get it. And it was homes that was growed up with grass and everything. So I want to know how you got a covenant and got the place looking so bad.
So Mr. Dent, that's the age-old argument of, why did you pull me over? Because there's other people speeding too.
Right.
And they say, well, you're the one I caught. So if there's an agreement in place and you own a home and it's covered by covenants, I have to follow the law as it relates to that.
Judge, am I able to ask a question?
I'm gonna allow you to ask a question, Ms. Dent, but it's really not proper, but I'm gonna, after you ask your question, I'm gonna let Mr. Looper put on his evidence and then we're gonna move this along. Go ahead, ma'am.
Yes, sir. I appreciate that, Judge. Thank you. Okay, so when we purchased the home, it was said that there was no HOA there. We went through the whole veteran process of not having a home with the HOA. And then their document that he's presented today that's saying that it was filed in 2006,
Yes,
where there
ma'am.
were no homes built there when we moved there. So when did this covenant become active? If it's filed, doesn't mean that it's active the moment it's filed, or is it active after the homes are built or after they go through the contract for the land that they had to purchase?
It's the short answer to your question is that it's active on the date of filing. Generally, the process of building a subdivision takes many years, and you have to go through zoning processes. You have to present what you're going to do. You have to get a plat summary done. You have to get soil tests done. There's a whole lot of stuff before you can build one home. And so all of that stuff gets taken care of way before one home is built.
So there were no documents in the courts when they did the paperwork to discover whether there was a HOA in that community or not? That
It-
wouldn't have been in the
According to what I see, there is a document filed on filing
John, I'm
date
sorry-
is May
I'm sorry to
25th.
inter-
Yes, sir.
I'm sorry to interrupt. Should I log on to my desktop computer, share the view so they can see the different exhibits what you and I are discussing, because they are at a disadvantage not seeing the documents,
Okay,
to be fair,
hold on. Let me try to.
unless you can do it on your end.
Yeah,
Thank you very much.
you can, Mr. Looper, because you're probably better at it than I am.
I don't know about that.
And so he's going to, I'm going to allow him to share his screen. And you should be able to share it, Mr. Looper. He's going to show you the documents. So it was filed in the Superior Court of Clayton County. And it's within the, it probably was within the real estate division, and it'll say book number X, page number Y, to show exactly where it is back in the dusty files where they keep everything. So it was in existence. If you made a specific request, Mr. Dent, that you do not move into an HOA and you had a realtor, that may be an issue between you and your realtor.
And Jerron, I'm sorry to interrupt again. Just as a housekeeping point, I am trying to do the screen sharing from my desktop, and it says host disabled participant screen sharing. So if your staff can make it possible for me to do it, or if you're able to do it on your end.
I just did all participants.
That's okay. Let me see. So.
What is that?
You see, yep, I think I can see it now. All right. Are the defendants able to see when I hit screen share what's on
Yes.
my screen? Okay. So just the two documents we've talked about so far, and I'll get into more detail once the testimony begins. This is Exhibit 1, the covenants that we've been referencing and the filing information, and then Plaintiff's Exhibit 2 is the quitclaim deed that we referenced, but which you all were aware of. But it's Plaintiff's Exhibit 1, and then we saved specific sections that govern our client's rights and what we're going to prove here today. But I'll go through that in greater detail shortly. So So Your Honor, I mean, you let us know if you would just like us to proceed or if there's other housekeeping we need to do first.
Well, I did this to hopefully, so Mr. and Mrs. Dent can understand kind of the posture and the procedure of this. As I understand the case, taking everything as true from Mr. Dent and Mrs. Dent, they didn't know that there were covenants and that there was a specific request to not live in a community with covenants. If that request was made and your real estate agent or realtor placed you in a community with covenants, that's something between you and the realtor. It's not between Mr. Luper's client or the HOA. But if you want to go forward, Mr. and Mrs. Dent, we can go forward. If you want to take an opportunity to speak to Mr. Luper about a possible resolution of the case, you can do that. Because I understand you, Mr. Dent. If you made that specific request and the person you made that request to didn't honor that request, then that person may be responsible, may be the person responsible.
And Your Honor,
Yes,
each
sir.
time that I refinance and they didn't find nothing with that, then, or there's some liability on that end also.
Potentially.
Because I refinanced twice. Normally when you refinance, you got HOA, they want to catch up your fees or something before you get through the next process. None of that happened.
And that's beyond my purview, Mr. Dent. If you want Mr. Luper to put on his case, I will allow him to put on his case. If you believe you want to try to just meet with Mr. Luper and his client to try to resolve this matter so that you can then move on to the person that may be responsible, I'll allow that to happen also.
Okay, well, yeah, I'll talk with him because the only thing, since I had no knowledge of it and stuff, only thing I'm probably concerned with, if it's something I gotta pay, then I don't want to be having to be subject to all these late fees for something I had no knowledge of.
Well, it doesn't necessarily work that way, Mr. Dent, especially on the day of trial. These are conversations that should have been ongoing in trying to resolve matters. But
with the lack of knowledge that we have, Judge, I do apologize for speaking without asking, but with the fact that we had no knowledge, I knew I have been called on jury duty, and I knew in the Clayton County, when I did jury duty, no one could force you to join a HOA when you were there before the HOA even arrived. From our knowledge,
you said you purchased a home in 2017, is that correct?
Yes, sir. But to our knowledge, there was no HOA through the whole processes that we went through, and the homes weren't even built behind us. So we had no knowledge.
So ma'am, that is not the fault of the HOA.
I understand, sir.
That would be the fault of the person that was helping you to find your home.
Exactly.
So they would be entitled to damages, possibly attorney's fees, and late fees.
Okay.
So if you want to go for it, we're going to go for it. You want a trial, you're going to get your trial. But it's to me, it's like you can bang your head into a brick wall all you want. It's not going to change the result.
Right. And I believe my husband said we'll speak with Mr. Luper.
And
okay.
Your Honor, as long as it'll be a fruitful conversation, Your Honor, we've been patient here this morning and we'll certainly always open to a conversation. But as you've already suggested, on the eve of a trial where we can get an order today, potentially, the idea of providing a discount or an accommodation for their position, while personally sympathetic, professionally wouldn't change our client's position. We would say unless they're open to, looking at payment in full